Well, there are some breaking inputs which have just come in where Vice President Venkaiah Naidu has rejected the opposition bid to impeach the Chief Justice of India, Dipak Misra. This is the big story that we are tracking at this hour. Remember, there had been a petition that had been filed to impeach the Chief Justice of India, and that has now been rejected by Vice President Venkaiah Naidu. And for more on this, we're joined in by our political affairs editor Kartikeya Sharma. Kartikeya, what more information do we have on this?
See, we have been given to believe that the Vice President Venkaiah Naidu has actually rejected the motion on the ground that first it was publicly revealed before the Vice President could have a look at it. But most important of all, the charges against a Chief Justice or any judge has to be specific in nature.
Right.
It has to be described in great detail and specificity. What happened in this petition was that may be alleged in words like that, it may be assumed or used. So I think what it does is it defeats the purpose, because once the Vice President rejects it, there is no, I would say, chance for the Congress party, for the Speaker to accept it. Speaker will also reject it. So judiciaries or the impeachment of any judge can only take place through an act of parliament. You know, it is a parliamentary procedure. So now Congress party, if it's thinking of any other option, it's not legally permissible, because you can't go to judiciary to say you want to sack a judge. The sacking of a judge only takes place through a prescribed motion. You know, it's a very it's a very tough norm. You know, the petition has to be accepted, it has to be scrutinized. Then 3 people will see whether there is merit to it or not.
Okay.
And then you need 2/3 majority in both houses of the parliament.
Absolutely indeed. Now, Kartikeya, there are 4 specific charges that were levelled against Dipak Misra. Let me read out a few of them. The first charge, of course, relates to the conspiracy to pay illegal gratification by people in relation to the Prasad education case. And there is a case that has been registered by the CBI in this. Now, there are 3 more, if I could just go through a couple more on this. The second one relates to Chief Justice having dealt with the administrative as well as the judicial side with a writ petition which sought an investigation into the matter of Prasad Education Trust. A lot of people have said that Dipak Misra should have recused himself from hearing this case, and also there was this issue of Dipak Misra being the master of the roster in allocation of cases. This was something that was brought out by Justice Chalameshwar, and he said that, look, there is a gross violation in the manner in which cases are in fact being allocated perhaps to certain benches to try get favourable judgment. Now, that is a specific and serious charge that was levelled by Justice Chalameshwar along with 3 other senior justices of the Supreme Court.
You see, what happened when Chalameshwar and 3 other judges, they made a charge against the Chief Justice of India. Please remember, it was that the recommendation of the Chief Justice of India is not being accepted by the Government of India, and Government of India is interfering into the work of the judiciary. That was the charge. Politically, it has created, it's like a harakiri for the Congress party. You have allowed executive and the judiciary to close rank. The senior judges, apart from CJI, were protesting against the interference of the law ministry in terms of appointment in the higher courts. And now what you have done is, by this political action, you have not only made them close the rank, but Saleh, you have reignited a debate. Please remember, in 1970s, it was Indira Gandhi who superseded 4 judges. And then the 5th in line went on to become the Chief Justice of India.
Right.
He went on. He went on to serve the Government of India. For example, the Chief Justice Beg almost ended up defending the emergency, and when he retired, he was appointed as appointed not only as one of the in the important constitutional position, but he was rehabilitated even by then Prime Minister Rajiv Gandhi. Same goes for Venkaiah Misra, who who looked into the violence against Sikhs, and later he was appointed as the first chief of the Human Rights Commission. So the link between judiciary or the politically compromised CGIs and the government, and especially in context of the Congress party, is not something which is not there in the public memory. It is there. So I think Congress should be far more careful on these issues, because ultimately what is happening, if I leave other issues of history aside, politically it's a problem for them for one simple reason, because the problem was between the political dispensation, the CGI and the senior judges. By Congress getting in, it has allowed the other people supporting the CGI to close ranks with the government.
Absolutely. And also, Karthikeya, do you think this is an issue that has now been extremely politicized? Because there are certain sections who are actually accusing that, look, there are charges against Dipak Misra, which is the reason why he's become more pliable by the government. And this is essentially the charge that they are levelling against him.
Yes, I would say that there are charges against Dipak Misra. There are allegations against Dipak Misra. There is no doubt about it. They have been published all over the newspapers. But when these charges go to the chairman of Rajya Sabha or the speaker, then they need to be definite.
Right.
It needs to have some sort of a fact history. That is why when you say that I want to move against the CJI, you don't move against CJI on the basis of allegations. And lastly, and most important of all, what is becomes central to the debate, as you asked me, is the independence of judiciary.
Right.
You see, that is where the political problem is. Congress might think that this is the right thing to do,
right,
but the fact is it is not being perceived as the right thing. And in politics, the perception of what you do is far more important than what you believe is right or wrong.
You know, this is almost unprecedented that a motion to impeach the Chief Justice of India was brought in. Nothing like this has happened before. Do you think this will now damage to a certain extent in the manner in which judiciary, which was seen as the final frontier, which was seen as above being questioned, now even that will now be questioned from henceforth?
We are forgetting one gentleman in the Indian politics, and the name of the gentleman is Dr. Manmohan Singh.
Right.
Dr. Manmohan Singh can be blamed for a lot of things, but Dr. Manmohan Singh cannot be blamed for any impropriety in public life. Dr. Manmohan Singh has never been blamed for any personal corruption. And in this case, Saleh, Dr. Manmohan Singh the former Prime Minister did not sign it. I think some credence has to be given to that man as to why he was not part of it. And please, it's not the first time. Please remember, it's not the first time.
Right.
It is the second time he has done it. I remember in one of the standing committees, when Digvijay Singh wanted to interrogate Urjit Patel and ask him certain delicate questions regarding the security of the country, Manmohan Singh snubbed Digvijay Singh. Manmohan Singh snubbed him and said, this cannot be asked. So in terms of propriety, please understand, for Manmohan Singh not to participate means something.
Absolutely. And lastly, just before we have Majid Memon, who's in fact reacting to this. Let's listen to what he's saying.
Else to do. The chairman of Rajya Sabha will do his duty. We don't want to push him either way. देखिए, प्रधान राज्यसभा के अध्यक्ष के पास इम्पीचमेंट की जो प्रोसीडिंग्स अब आई है, वो उन्हें संवैधानिक तौर पर उन्हें उसका आगे उन्हें कार्रवाई करनी है। जहाँ तक कि राष्ट्रवादी कांग्रेस पार्टी और हमारे नेता शरद पवार जी की बात है, हम ये स्पष्ट करना चाहते हैं कि न तो हम किसी के पीछे पड़े हैं, ये जो मुख्य न्यायाधीश को हटाना है, कोई मकसद हो, कोई राजनीति हो, ऐसी कोई बात नहीं हमारी। हमने ये कदम सिर्फ इसलिए उठाया है कि हम चाहते हैं कि सुप्रीम कोर्ट का जो दर्जा, सुप्रीम कोर्ट का जो वक़ार, सुप्रीम कोर्ट की जो इज्जत है, वो बनी रहे। And explosive statements which is becoming a fodder for the media. It's a fact because we have recently seen after Kathua that no other than the minister in Union Cabinet makes a statement that in a vast country like India, the incidents like Kathua can always take place. Well, this is something devastating. And I'm afraid what the Prime Minister has said, with what seriousness did he say, with what seriousness it would be taken up by the concerned MLAs, MPs, and with what seriousness would the party take action against them if they still defy. We will have, only time will show this. Well, the chairman of Rajya Sabha has his constitutional obligation to discharge. And I'm sure that he would be discharging it absolutely fairly and in keeping with the established precedents and principles of procedures for impeachment. As far as our party is concerned, Mr. Sharad Pawar has made it extremely clear. We don't want to witch hunt, whether it is Chief Justice of India or any other judge for that matter, nor are we a party to this impeachment process for any political ulterior.
All right, so that was Majid Memon there stating that this of course, is the prerogative of the Vice President, and his party will, of course, have nothing more to question on it, stating that it is important to respect the independence of the judiciary, and that was the stated position of Majid Memon there. And also, I'm told that we are joined in by our correspondent, Jessica Taneja. Jessica, this, of course, is a big, significant development where Venkaiah Naidu has now rejected the demand for the motion to impeach the Chief Justice of India.
Absolutely, Mohammed. And the fact that we saw it coming, but we were just waiting for the explanation as to what it is. Now, according to my sources, they say it's a 20-page document which details the fact that there are some legal implications as well. And also, you would know, Mohammed, that in the past as well, it is very difficult to impeach a sitting judge in India according to the law, Article 24 of Judges Act as well. It is absolutely impossible. The way it's been laid down in the procedures of law, it is difficult to impeach a sitting judge. Also, the fact that there was also another point raised in that 20-page document which clearly said that the 7 Rajya Sabha MPs or who were part of it, the upper house members who were part of it, have retired. So there were legitimately 64 signatures too, but that is not one of the grounds. The grounds are set completely on legal implications. Now here, the Congress and other opposition parties have a chance to go back and review it, but at the moment it's up to their call as to what they would do. But it's a clear rejection coming in from the Vice President, who has rejected this impeachment motion.
Absolutely, indeed. And also, Jessica, considering the fact that the judiciary itself at this point of time is a bit of a divided house after that unprecedented press conference that we saw by the 4th senior Supreme Court judges there, have you heard anything at all from them after the Vice President has rejected this motion to impeach the Chief Justice of India?
Well, currently not from, the judges at this point in time, but what we've known is that things have been really problematic inside Supreme Court corridors as well as senior judges' courts. But we haven't heard anything from the senior judiciary right on this point in time. But that press conference also led to a point where the Congress and opposition united, but they were waiting for the right moment. They had already drafted the impeachment motion about a month ago, so what we told by the sources of the Congress party, but they had not moved it yet. What was the trigger for them was Judge Loya's judgment. But then again, this is a failed attempt, as it has been in the past as well. It has been clearly outrightly rejected in the upper house, even when the Congress had a majority in the upper house to move an impeachment motion. So, but this has clearly failed to pass now.
Absolutely, indeed. Jessica, do continue to stay on with us. Meanwhile, I'm told that we're also joined in by Mr. Virag Gupta, who is a constitutional expert. Good morning to you, Mr. Gupta. Thank you very much indeed for joining us on this broadcast here in WION. Now, these are big, significant developments that have taken place where a motion was in fact moved to impeach the Chief Justice of India. This is unprecedented. Never in the history of independent India has a motion of this nature been attempted to be passed. And now the Vice President of India, Mr. Venkaiah Naidu, has struck down that motion.
Hello.
Hello, Mr. Virag Gupta. Can you hear me?
Yes, please.
Okay, my question to you was, what do you make of Mr. Venkaiah Naidu, the Vice President, striking down the motion to impeach the Chief Justice of India?
There are 3 aspects are there. I think that as per the law, he was not supposed to make a call whether it is politically motivated or not. He was only supposed to verify whether the 50 signatures are authentic or not, and whether this motion is as per law, and whether the grounds given are there as per the Article 124 of the Constitution.
Okay.
Now, as per the law, as per the judges, this inquiry committee, he was to frame that judges inquiry committee. Now, there is a complication that how can that be framed? Okay. In that committee, 2 members are to be, one from the Supreme Court judge and one is from the High Court Chief Justice. Now, how can a subordinate judge in the Supreme Court or a High Court Chief Justice can inquire against the Chief Justice? That is the big complication, because the makers of the Constitution never thought that one day Chief Justice can also be impeached. So there is no such precedent.
Okay.
Now, the second problem is that the order, this rejection by the Vice President or the chairperson of the Rajya Sabha, it cannot be appealed. So the only remedy is to go against this order before the Supreme Court under Article 32 of the Constitution. Now again the question is that who will listen this matter? Because impeachment, the Chief Justice, as per the roster, these all PILs are to be heard by the Chief Justice. Now Chief Justice can't hear their own matter. Now the second problem is that one of the allegation in this motion was that 4 judges conference was one of the ground in that motion. Now the 5 senior judges cannot hear this matter. So who will hear this matter and who will direct, and what will be the legal options further are there? I really doubt that this is I can say that this is a constitutional crisis.
You say it's a constitutional crisis. Okay, but what is the way forward here, Mr. Gupta? This is, this is an unprecedented sort of a situation that the Indian judiciary finds itself in. Now, you say that the fact that Venkaiah Naidu has rejected this motion cannot be appealed against. So how do we take this forward?
No, there are 2 aspects are there. The first aspect is that everybody was knowing that this proposal is not going to be through because these MPs don't have majority in both the houses. So it was not going to be through. This is something, naturally this is a political move only. But there are both aspects are there that after this rejection by the chairperson, what these MPs are going to do. And secondly, judiciary, how it is going to be impacted by this motion and how, whether they will call the full judge meeting, whether they will refer this matter or some internal inquiry committee is going to be set up. Because the main person, one of the main judges of the Allahabad High Court, judicial work was taken from that judge. What further action has been taken, what judiciary in-house action will be taken, this is also going to be seen.
Absolutely indeed, Mr. Gupta. Do continue to stay on with us. Meanwhile, I still have our political affairs editor Kartikeya Sharma with me. Kartikeya, this is also as much a matter of judiciary as it is about politics. Now, one of the grounds which Venkaiah Naidu has stated, he said that, look, this is a politically motivated sort of a motion and there are not adequate enough grounds for a motion of this nature to be brought about. Do you expect this issue to die down anytime soon, or will there be more politics which will be played on this issue?
I think now after this, it's a bit of a problem for the Congress party because now if Congress wants to go to the court, as Mr. Gupta was saying, who's going to listen to the petition? Are junior judges going to listen to a petition against the Chief Justice of India? Does the opposition wants to break whatever semblance of, the judiciary you have? You want to create a position whereby junior judges can start speaking against the senior judge. It's like the High Court judge, Mr. Kandan's case. He passed a judgment against the Supreme Court of India. The Supreme Court of India had to actually send a stern message. He was arrested after 6 months, And then again the question became, it was a twofold dialogue. How come a person like Kandan went on to become the Chief Justice of a High Court? And secondly, how come a High Court judge was passing strictures against the Supreme Court judge? So I think this delicate situation must be dealt with now. They went for a pitch, they have lost it. I think by going to the Supreme Court will not serve any function. Most of the judicial or the people in judiciary will close rank. No one will try to create a situation whereby junior judges will create a precedent of sacking senior judges. If you can do this today, you'll be doing it for next 50 years. No one will allow this.
Absolutely indeed. And also, Mr. Viragutta, if I could come to you for quick closing comments here. Some of the people who have said that this motion was important. They have said that all they are looking for is a judicial committee to inquire into the charges against Dipak Misra. And if this committee were to rule that indeed the charges have a certain basis on which a case can be pursued against Dipak Misra, then no party would be able to oppose the motion to impeach the Chief Justice of India. This is what some of the activists who wanted this motion passed have said. Now, with this being the case, do you expect the opposition to still pursue this case forward and appeal in the Supreme Court to have a motion of this nature passed?
One more legal option is there which can also be explored and which will give more power to this motion. And that is to gather the support of 100 MPs and move the motion in the Lok Sabha.
Right.
So by moving the motion in the Lok Sabha, it will have more authenticity and it will give more moral authority to the motion, and it will reflect that the opposition has majority, opposition has the consensus for this motion, not only in the Rajya Sabha but in the Lok Sabha also. And by this, the purpose of this motion is to debate the judiciary, debate the role of the judiciary, and instead of going to the Supreme Court, I personally feel that they should gather the support of 100 MPs and move the motion in the Lok Sabha if they are really serious.
Absolutely indeed. We'll have to leave it there. Thank you very much indeed, Mr. Virag Gupta, Kartikeya Sharma, and also my colleague Jessica Taneja for having joined us on the broadcast. So that is one of the options which the opposition has. Can they get the support of 100 MPs now in the Lok Sabha? The big question is, do they even have the numbers for something like that? But apart from that, it appears that this motion to try and impeach the Chief Justice of India has now hit a roadblock. This is an unprecedented situation. Never in the history of independent India has a motion of this nature been attempted. And meanwhile, Naveen Kohli is speaking. Let's listen to what he has to say.
Of the constitutional scheme or the independence of the judiciary. The judiciary and the Supreme Court is an institution of eminence. Every judge who is there is an institution by himself or herself. They can collectively decide how the institution is to run. They don't require a political party outside running on the street with a set of advocates to decide how they have to function and try to bring their political agenda onto this. So if the Vice President has decided, he must have done so on merits. The Congress certainly can't claim high moral ground on any basis, because what they are doing is purely political, not driven by any constitutional background or driven by any constitutional concern.
एक सवाल, संविधान बचाओ रैली की प्रोग्राम की शुरुआत कर रहे हैं।
संविधान तो इस देश में उस दिन उड़ गया था, और उसकी बचाव के लिए अगर उनको रैली करना है तो पहले जाना चाहिए और 1975 के आपातकालीन के लिए माफी मांगनी चाहिए। संविधान पर एक ही बार हुआ है पिछले 70।
All right, so that was BJP leader and lawyer Naveen Kohli there, stating that each Supreme Court judge is an institution by himself, and if the Vice President of India has decided to debunk this motion, then he must have done so on some sound grounds. But these are unprecedented developments. The situation is an extremely delicate one, because if this motion had been allowed to be brought in, there would have been a judicial committee which would have looked into the charges. There are 4 to 5 very specific charges which have been levelled against Dipak Misra. The opposition is, of course, stating that the reason why Dipak Misra is so pliable in the hands of the government and as to why his independence is in question is because they feel that the government is actually blackmailing Dipak Misra to try and give them benches which will lead to certain favourable judgments. Now, this, of course, is the accusation levelled against the government by the opposition leaders. But for the time being, as the case stands, Venkaiah Naidu has decided not to let the motion proceed further. Now, we also spoke with Mr. Virag Gupta, who is a constitutional expert. Now, the way forward this can be pursued is the opposition can now go to the Supreme Court against the ruling that's been given by the Vice President. They can appeal against it, but then who will listen to the case? Because a case of this nature will obviously come to Dipak Misra, and will he be able to listen to this case, or if he were to recuse himself? Because remember, the case of corruption and the case of impeachment is against Dipak Misra, then will a junior judge listen to a case of the motion for the impeachment proceedings against the Chief Justice of India? This is something which is a bit of a grey area in the Constitution. It is not very clearly mentioned in terms of what is to happen here. But the other option which the opposition can also look at is they can now try to get about 100 signatures from the members of the Parliament of the Lok Sabha and see if a motion can now be brought in, because that would, of course, give greater legitimacy for a motion of this nature. Now, this of course is an extremely delicate situation, something which perhaps the makers of our constitution had not expected. Never in the history of independent India has a motion of this nature been brought against a sitting Chief Justice of India. There are 4 or 5 very concrete allegations of corruption that have been levelled against Dipak Misra. The opposition says that, look, Dipak Misra is someone who is pliable essentially because he's being blackmailed by the government because of these charges of corruption. And our political affairs editor Kartikeya Sharma has more updates on this. Go ahead, Kartikeya.
I've got the copy of the order. The copy says, and I'll read it to you, the important operative parts of it. I have received a motion, a notice of motion on 20th April 2018, signed by 64 members of Rajya Sabha under Article 124(4) of the Constitution of the removal of Mr. Justice Dipak Misra. Chief Justice of India, the terms of motions are. Now, it goes on to say, the House resolves that an address be presented to the President of India for removal of Justice Dipak Misra from the Office of Justice of India. Now, the important part here is, what does this order say?
Right.
The order says, in which is signed by Venkaiah Naidu, in the instant case in the notice of motion is against the Chief Justice of India, it is not feasible to consult or seek advice of Chief Justice of India. I thought it fit to consult legal luminaries, constitutional experts, former Secretary General of both houses, former law officers, law commission members, eminent jurists who generously shared insights based on their rich experience.
Right.
So he said whom he consulted. Then he said, I have also gone through the comments made by former Attorney General, constitutional experts, editors of prominent newspapers, and people who commented on it. Then he says, I have a detailed personal conversation with some of them on all the aspects arising from notice. I have considered each of the allegations individually as well as collectively in the light of annexures annexed to the notice of the motion, but also in the light of cogent relevant material available in the form of judicial order passed by the apex court of the country. And then he says, Article 124(4) of the Constitution uses two expressions for consideration of any such motion. Firstly, proved misbehavior, and secondly, incapacity. Proved misbehavior is an expression clearly distinguishable from misconduct as an apparent from the language of Article 124(4). The intent, gravity and onus of them is higher. The prefixed proved places an obligation of actually proving the misbehavior before the parliamentary procedure for removal of judge can come into play, as I said. But the important part comes here. He says the honourable member of parliaments who have presented the petition are unsure of their own case.
Okay.
Page 1 of the petition uses phrase such as the fact and the circumstances related to the Prasad education case. And has been telling you, he said, Vice President says, suggesting that the Chief Justice of India may have been involved in the conspiracy of paying illegal gratification. The motion further states that the CJI that he too was likely to fall within the scope of investigation. It further states the Chief Justice of India appears to have antedated an administrative order. I am mentioning the fact because phrases used by honourable members of parliament indicates a mere suspicion, conjuncture, or an assumption. And this is the point I have been trying to make since morning, that it is this reason which will be considered, because your charges needs to be definite. And then the Vice President goes on to say, a bench of 5 honourable judges has also reaffirmed and settled position that CJI is the master roster. So he also uses the position of the 4 CJI. 4 judges in the Supreme Court, and recently in the case of Kamini Jaiswal versus Union of India, 14 November 2017, the court has observed, Constitution bench of the court held that what has been laid down in Prakash Chand would apply as regards to the power of the Honourable Chief Justice of India. And coming back to the last point, though he has made, I think he's gone into great detail, Venkaiah Naidu, in passing, I am constrained to observe that in this matter, the well-established parliamentary custom and convention have been delineated in the paragraph 2.2 of the handbook. Members of Rajya Sabha have been disregarded. He says it has been disregarded. The provision prohibits publicity of any notice submitted by member till it has been admitted by chairman and circulated to the members. In the instant case, immediately submitting the notice to me on 20th April, members addressed a press conference and shared the unsubstantiated charges against CJI. This act of members of discussing the conduct of CJI in press is against propriety and parliamentary decorum, as it denigrates the institution of CJI. I am also aware that there have been a spate of statement in the press that seems to vitiate the atmosphere. I thought I should therefore expedite my decision and end needless speculation. So I think this is a very strong statement, a very strong order on part of the Vice President, Saleh. You know, generally Vice Presidents, presidential orders are very circumspect, and even the opinion comes in the end. But this is a 9-page order he has given, and out of the 9-page order he has gone into detail. For example, in the absence of credible and verified information placed before me, which gives an indication of misbehavior or incapacity, it would be inappropriate and irresponsible act to accept statements which have little empirical basis. So basically, he has thrown this petition into a dustbin, saying that it is not based on fact, and he has written it too.
Okay, now Karthikeya, the opposition will of course turn around. Now what we have on our screens is the order that has been passed by the Vice President Venkaiah Naidu here. He has dismissed the motion that was attempted to be brought against the Chief Justice of India, Dipak Misra, stating that it is based on unsubstantiated facts, that look, the grounds on basis of which the motion for impeachment are actually not very sound. But Karthikeya, the point which perhaps the opposition will make is this. You know, in the Prasad Education Trust case, the gratification that has been paid, the illegal gratification that has been paid, there is an FIR that has been registered by the CBI. So no less than the CBI has registered an FIR in the case. So there are certain questions that need to be asked. Now also, the other allegation that has been levelled against Dipak Misra is that while he was an advocate, he actually had acquired land by giving an affidavit which was later found to be false. Now, these are reports in the media. These are all allegations that have been levelled, and they have said that an affidavit was filed by Dipak Misra when he was an advocate at the time of purchasing land, and that was found to be false. So this is what the opposition will harp upon.
CJI can file a case on the basis of suspicion. That is the right of the investigative agency. So I'll read what the Vice President wrote.
Okay.
The honourable members of parliament who have presented the petition are unsure of their own case. Page 1 of the petition uses phrase such as facts and circumstances related to Prasad Education Trust case show prima facie evidence suggesting that the Chief Justice of India may have been involved in the conspiracy of paying illegal gratification. The motion further states with regard to Chief Justice of India that he too was likely to fall within the scope of investigation. It further states the Chief Justice of India appears to have antedated an administrative order. I am mentioning this because the phrases used by honourable member of parliament themselves indicate a mere suspicion, conjecture or an assumption. The same certainly does not constitute proof beyond reasonable doubt, which is required to make a case of proved misbehavior under Article 124/4. Conversations exist between third parties with dubious credentials have been extensively relied upon, cannot themselves constitute any material evidence against the holder of the office of Chief Justice of India. So, you know, I think important thing here is, see the strong words which the Vice President has used.
Okay.
Clearly, this is an internal matter to be resolved by the Supreme Court itself, going through the 5 allegations mentioned in the notice. I am of the view that they are neither tenable or admissible.
You know, if I could just interrupt you there, Karthikeya, it's interesting that the Vice President says that this is a matter that needs to be resolved by the judiciary in itself. But the fact of the matter is, this is again an unprecedented and delicate situation where the judiciary itself is a bit of a divided house, where Dipak Misra is the Chief Justice of India, and the second most senior most judge immediately after Dipak Misra is, Justice Chalameshwar, who in fact came out and gave that unprecedented press conference saying that, look, there are certain things which are happening within the judiciary which are completely out of order. So how do we expect the judiciary to sort this matter on their own, which the Vice President is expecting them to do?
Issue is that in judiciary, the judges are actually complaining against the interference of the central government. They are saying that the Chief Justice of India is welting under the pressure of the central government. They are not blaming the Chief Justice of India. They are blaming the law ministry. They are blaming the central government. Politically, it's a self-goal because Congress, what it has done is that it has led to other judiciary. 4 judges spoke against the Chief Justice of India. What about the 44 others? None of them spoke. So the issue is that you have a lot of 50 judges in Supreme Court, 4 judges are speaking, the 44 judges are quiet, which means the rest of the judges will all rally behind CJI, which means the Congress has politically and judicially isolated itself. I think these are issues on, I don't know why this decision was reached upon, because I distinctly remember when I spoke to a very senior Congress party functionary, he has not signed it. Former Law Minister Salman Khurshid is not on board. Former Finance Minister, former Home Minister Chidambaram is not on board. It's not a Prime Minister, Dr. Manmohan Singh, former Prime Minister, is not on board. So I think there has to be merit in this case for former PM not to sign the petition.
Okay, we'll just come back and discuss as to why some of the senior Congress leaders themselves have not signed this motion that some members within the Congress wanted passed. But first, let's listen in to what Nalin Kohli had to say after the decision by the Vice President.
The only assault on the constitutional setup was under Srimati Indira Gandhi ji, which was emergency. And after that or before that, there has never been an assault, or the constitution has not been under threat. Under Prime Minister Narendra Modi ji, it functions exactly how as the constitution is to be there. With regard to it, if he wants to, then he should perhaps start by going and expressing remorse, regret and apologize for the emergency, and then give advice to his party colleagues that never again will there be an assault on this, on the Constitution of India, as it happened under Srimati Indira Gandhi ji. And what is currently happening, is this not an assault on the independence of the judiciary, on the constitutional scheme of a political party trying to fight its political existence on the basis of these kind of moves? In trying to determine which judge should hear which matter, which bench should hear which matter, how should the court function, where should matters go, when should they be heard? The judiciary is an independent, eminent institution. Every judge there is in the Supreme Court is an institution of eminence. They will decide. They don't need Mr. Rahul Gandhi or his party's advice on how to run the judiciary.
All right, so that is what BJP leader and senior lawyer Nalin Kohli had to say about the Vice President trashing this motion to impeach the Chief Justice of India. Our political affairs editor, Karthikeya Sharma, is still with us. Now, Karthikeya, you were speaking about the fact that some senior Congress leaders, former Law Minister Salman Khurshid has not signed it, former Prime Minister Manmohan Singh has not signed this motion. Do you think the Congress itself is a little divided in pursuing this motion to impeach the Chief Justice of India?
I think the divide is pretty out and open for the simple reason the former Prime Minister is not on board. Even Chidambaram is not on board, or for example, Salman Khurshid did not sign it. You know, he is a former MP, former law minister, he could have signed it. But the bottom line is that ultimately these issues become issues of propriety, morality, public perception. Now you are accusing that the CJI is not behaving the way it should be. Look at the way the way Chief Justice were appointed during Indira Gandhi's tenure. Why was Beg given a political position? Why was Ranganath Mishra given a political position? Why was the Chief Justice of the person who had to become the should have become the Chief Justice was superseded by superseded by the 4th judge, and 3 senior judges had to resign? Why did that happen? What happened in the Keshwanand Bharti case, where Indira Gandhi wanted the earlier case of the Golaknath versus State of India to do away with the debate on the basic structure of the Constitution? Right. She was against the fact that the basic structure of the Constitution cannot be amended, and in fact she was the person who spoke about the committed judiciary. I think Congress has a lot to explain, and I think I would read this out to you. In this, Venkaiah Naidu says that the provision of the Constitution bears ample testimony to proposition that the Constitution seeks to establish and nurture an independent judiciary. The founding fathers of the Constitutions were eloquent about it. Various articles of the Constitution seek to protect the independence of judiciary by providing appropriate safeguards, and unwarranted interference by legislature or executive with the judges' conditions of service privileges incidental to the membership of the constitutional courts. So I think that is one part of it. But I would again like to reinforce, it was a game which the Congress party could have won. It stepped in early.
Okay, and now there is another alternative that the Congress party and the members of the opposition also have. They can get 100 signatures in the Lok Sabha to pursue this motion forward. That would, of course, give them greater legitimacy. Do you think they can do that? Do they even have the numbers?
Moral legitimacy does not mean political green light. Even if you have 150 MPs signing it, if Speaker rejects it, then?
Right.
If the committee appointed by the Speaker says that it has no merit, then? And despite that, you can't get 2/3 majority, then? And the CJI retires in October. So, you know, this case does not have merit. You know, the budget session is over. You will have monsoon session in June, July. He's going to retire in 3 months. The procedure for removal of the justice or any senior judge in India takes 8 months. That's the prescribed time. Even if tomorrow the removal starts, you cannot impeach him before he, by October. By October, he's going to retire, which goes on to show that there's a political intent behind it. And I really don't understand why a seasoned party is hell bent on committing political harakiri on such an issue, which does not even have electoral dividends.
Right. We'll have to leave there. Thank you very much indeed, Kartikeya Sharma, for joining us and getting us all those inputs. But some people will, of course, turn around and say that if the Judicial Committee was indeed formed and in the course of their investigation they found some merits on the accusations that have been leveled against Dipak Misra, then which political party would not want to back impeachment? That, of course, is the big question. But this is a debate that is not going to die down anytime soon. It is an unprecedented situation in the Indian judiciary. It is an extremely delicate situation. And as things stand at this point of time, Vice President of India, Venkaiah Naidu, has decided to trash this motion that was sought to be moved for the impeachment of the Chief Justice.
Members of Parliament are free, if the numbers are there, to move an impeachment motion within the Constitution, but equally the chairman of the Rajya Sabha has the right to reject that petition on grounds that he believes are valid.